right. Well, hello, everyone. Happy Friday. I hope you can hear me okay. Nice to see you. It's Fran McGovern again. First Friday with Fran. Welcome to November. We have Thanksgiving creeping up on us. And let's see, let's start off with our usual announcements, right? The usual boring legal stuff. You know, the webinars are provided for general informational discussion purposes only. The webinars do not and cannot form an attorney-client relationship. The information is exchanged does not constitute legal advice, right? We all know this. To obtain legal advice, you got to go out and hire a lawyer like us or somebody else. And nothing that we talk about here will be confidential. So don't tell me any secrets because everyone else on the chat will hear it. Hi, Gene. So we'll go dog of the day. So we have two dogs of the day today. Let's see. There we go. This is Bowie and Max. I think it's Bowie on the left there and Max. And Bowie and Max are owned by Stacy Homa of Atlantic Realty. Thanks so much, Stacy. Beautiful dogs with a beautiful view. They look like they live in a nice place. Atlantic Realty is down by Atlantic City, outside of Atlantic City, and they do a lot of work in Atlantic and Cape May counties in particular. So thanks, Stacy, and great dogs. And let's jump right in. So the title of today's webinar is Not Our Job, Not So Fast, because this comes out of a surprising case from 2005 that lots of people overlook and ignore. It's a case called Siddons versus Cook. But before we get to Siddons versus Cook, let's think about how we get to liability, right? So liability, if something goes wrong, what do you generally need for a lawyer to impose liability? You usually need four things. Duty. You need to show a duty. Then you need to show a breach of that duty. Then you need to show causation. And then you need to show the damage that results from the breach of the duty, right? And it has to be proximate causation. It can't be something like, but for the fact you were born, I would not have been injured. It has to be proximate causation. So it has to be causation that is linked to the damage and breach of the duty. So that's duty, breach, causation, and damage. That equals liability. If you cannot prove one of those items, you don't get liability against the defendant. So in this case, it was a very surprising case. Oh, let me go back to powers for a second. So that's duty. The next factor you have to think about, which sometimes implies a duty, is the power to do something. So oftentimes, if you have the power to do something, a court will imply a duty. Okay, so let's talk about how that works. So usually there's an express duty, going back to the second bullet point after dog of the day again. An express duty says the association shall maintain, repair, and replace the common property. Right? That's virtually in all the associations we work with. Right? So that's an express duty. It's actually outlined in there. Then there's an implied duty. And the implied duty may be something that the association has the power to do something. And even though there is not an express duty, the fact that the association has a power to do something suggests that the association may also have a duty to do it. Right? And power and duty should always go hand in hand, power and duty. A duty as a matter of law is generally something outside of your governing documents that may be imposed as a matter of law. There's a statute out there or a regulation that says you have to do this. So that's kind of how duties arise and how powers arise. And then the big question is, what are we talking about, Fran? If it's not our job, right? So this is the case that we're going to talk about in Siddons versus Cook. Typically, an association, and we're talking primarily about condo associations here, a condo association is typically only given the duty to maintain, repair, and replace the common elements and the limited common elements. And the unit owner is charged with maintaining, repairing, and replacing the unit owner items or the portions of the unit, right? So that's why most people say, hey, not a big deal. Why am I talking about Siddons versus Cook, and why am I talking about a case from 2005? Really, Fran, 2005 was a long time ago. I've never heard of Siddons and Cook, Siddons versus Cook. Why don't you leave me alone? When we get into Siddons versus Cook, what happened? So in Siddons versus Cook, Siddons was the downstairs unit owner. she came home one day and there was her unit was flooded out. And she found out after the management company came in that the upstairs unit owner's dishwasher water supply line had cracked and leaked, and the water was just flowing into her unit downstairs. And that's what caused the damage. That was the cause of the leak. Mrs. Siddons then sued Mr. Cook as well as the Country Place Condominium Association. So sued the condominium association and sued the upstairs unit owner. Said, hey, Mr. Cook, you should have taken care of your dishwasher, and you didn't, and you had a duty and you breached that duty, and I was damaged because of that duty, causally related. I have damages, and you need to pay me $25,000 for all the damage that you did to my lower unit. Okay. And what the court found there was proof that the crack in the supply line to the dishwasher, where it had cracked, was under the dishwasher and up and inside, more or less, in a hidden place inside the dishwasher. So it wasn't obvious, even while exercising reasonable care, that the unit owner would see that type of problem with the water supply line, a crack that would cause a leak and have water flow downstairs. So this is the trial level. So at the trial level, the court said, well, wait a second. They weren't negligent. Okay, there was a duty, yes, be reasonable in terms of caring for your dishwasher. But was there a breach? And the court answered that question by saying, no, there was no breach. It wasn't reasonable for someone to go into their underneath and pull their dishwasher out on a regular basis and inspect the hidden line parts that are included in a dishwasher. So the court said, since they can't show breach because they acted reasonably, even though there was causation, the water caused damage, and the damage was related to the water, there was no breach of a duty. They exercised reasonable care, and therefore they're not going to be able to collect damages from Mr. Cook, the guy upstairs. So then Ms. Siddons says, well, no, wait a second. This is strict liability. This isn't just negligence. This is strict liability, and a dishwasher is a dangerous item, and therefore it's strict liability. I don't have to show negligence. And the court said, no, this is not strict liability. Strict liability has to do with certain circumstances, and usually it has to do with inherently dangerous circumstances. So handling explosives, handling poison, things like that, where it's strict liability. If you're handling very, very dangerous items and someone gets hurt, many times it can be a strict liability case where you don't have to prove negligence. Here, though, the court said, no. Mr. Cook acted reasonably, dismissed. You get no recovery against Mr. Cook. And then they said, the court said, let's talk about Country Place Condominium Association, because you're also going after Country Place Condominium Association, saying that the Country Place Condominium Association should have warned the residents of the community that sometimes the dishwasher machine hoses break, and when they do, it causes damage to the units below. That was the claim of the plaintiffs. And the trial court said, wait a second, we're looking at the governing documents. The governing documents say that the association has a duty to maintain, repair, and replace the common elements and limit common elements, period. And we look at the governing documents further, and they say the unit owner shall maintain, repair, and replace their unit items, such as dishwashers, refrigerators, things like that in the unit. So the trial court said, we don't think so. We don't think the association had any obligation to warn you of anything. And the record at the trial level judge was not convinced that either the association or Mr. Cook had an obligation with respect to the damage that was done to the downstairs unit owner. The case went to the appellate division. And usually in the appellate division, it's a panel of three judges. And the appellate court said, no, we agree with you, trial judge, that Mr. Cook is not liable. Totally correct, trial judge. We agree He acted reasonably. It's not strict liability. There was no negligence. Therefore, you can't go after Mr. Cook. But what the appellate division said, however, is, hey, trial judge, you're wrong. We're reversing you. We look at the governing documents and we find some other things in there that implicates a duty with respect to the association. So they looked at the governing documents and they said, yeah, we understand, trial judge, that the association is responsible generally for common elements and the unit owner is responsible for unit elements. However, there's a further provision in your governing documents that says the association has the ability, if there's a hazard, to go into a condominium association unit and repair something that the unit owner has not repaired, or at a minimum, um, warn the unit owners of the situation. And the association still protested and said, no, 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 that's not right. That's just if we are aware of a particular circumstance and the unit owner fails to address it. And the court said, no, we find that those types of provisions implicate a duty to warn because the association is in the best position to warn and collect information regarding unit owner defects that impact other units or the common elements. And here's the key fact here. At least 3 or 4 times prior to Miss Siddons getting flooded out in her first floor unit, the association had other similar cases. So what was happening here that the trial judge did not pick up on was that the association had reports 3 or 4 times prior to this case where the same break in the line inside the dishwasher happened and flooded it out. And what the appellate division said was, listen, you were aware of the hazard. We're not telling you, association, that you had to go in and replace and inspect every person's dishwasher, not at all. But we are saying to you that the association was aware of a situation, a defect in a unit owner item that you, association, were in the best position to warn about. So you should have sent out a notice to every unit owner explaining to them that they should check their dishwasher line, that we've had this situation reported to us before, and therefore, association, we are going to impose upon you a duty to warn. In this case, you were aware of ahead of time. You failed to warn. We're not going to render judgment against you to replace the dishwasher line, but we are going to render judgment against you for the $25,000 in consequential damages to the downstairs unit owner. That's a brutal outcome, right? That's a brutal outcome for associations. This decision, Siddons versus Cook, does not get into insurance coverage, so it's not clear from the decision of the appellate court itself whether or not this was an insurance subrogation case or the unit owners just didn't have coverage for the interior of the unit. So it's not clear from insurance coverage whether or not this was an insurance dispute. But it does raise some really important issues for condo associations in particular. And think about this. Where could this issue arise? So we have dishwasher hoses, right? Let's think about where else this might arise. Washing machine hoses. What about washing machine hoses where we know after a period of time, the washing machines hoses that were installed by the developer, the first owners, are starting to pop, and the association in a high-rise or a mid-rise or stacked condos are starting to pop. And the management company in their files has units have been washed out in May, units were washed out in August, units were washed out in October. When does the duty arise? I would say the duty arises when you have that first pop at a minimum, and maybe even before that. If somebody comes out and says during an inspection that, hey, your hoses are shot, and the association becomes aware of it, do the notice. What about dryer vents? Same thing. What if you have a dryer vent fire, right? Because your condo association has long runs of dryer vents and they're not being cleaned regularly and there's a lint buildup. Can the association under this case be held liable for damage from a fire that arises from a dryer vent, even though the dryer vent itself is owned by the unit owner? Quite possibly. What about chimneys? Chimneys and fireplaces that are part of the unit that are not taken care of, but the association is informed that there are problems with the flue or the chimney itself, right? And someone gets injured or there's a fire. What about windows in mid-rises or high-rises where it's known that the window structures that are owned by the units, the unit owners, are prone to leaks, or that the seals break or the flashings are not correct? Can the association be bearing a duty to warn the unit owners that the windows fail in the community or fail at a certain time? What about, and there are some questions and I'll get to them. What about furnaces? So we've had cases where there are defects in furnaces and the association becomes aware of them. And does the association have an obligation to notify the entire community that the builder installed furnaces are a problem, such as improper flues or carbon monoxide problems, elevated carbon monoxide problems? Again, most of this applies to condo associations. What about pinhole leaks in pipes? So there are some municipalities and some water systems where, because of the pH and the chemical balance of the water that runs through the pipe, it basically erodes the pipe walls themselves. And the association knows that the units, even though the unit owners own the pipes that are within their unit, they develop pinhole leaks, and the pinhole leaks will pop and flood the unit where the pipes are and the unit below. So that's something to think about. What about pipes in exterior walls or in uninsulated places that may be prone to freezing during the winter? So there are some associations, the way they were created, there are pipes and exterior walls that in very, very cold conditions, if the pipe is an exterior wall, the association knows that those pipes in those locations regularly freeze and pop, and there can be a problem. So think about that. What about asbestos? Fran McGovern goes, what the heck? What are you talking about asbestos for? Some condos, especially older ones, have asbestos in them, right? If there is asbestos in them, does the association have a duty to advise the unit owners that there is asbestos in the unit when the association becomes aware of it? I would say the association should advise the unit owners. Where do we see this? Old school. We're all been long enough to know and love popcorn ceilings, right? In many, many old school popcorn ceilings, there's asbestos in the popcorn ceiling. Not all of them, but in a number of them there is. And as you know, if you were into asbestos, if it becomes friable, which means if it starts to break down and have dust and people can inhale it, you can wind up with serious disease with respect to that. What about railings on front steps that are even owned by the unit owner? But the association knows that when the developer installed the railings, the where the railing is attached to the stoop, it wasn't done properly, and the railings tend to loosen and fall off. Does the association have a duty to warn? Decks are another one. We here have had this issue in an association in Ocean County. Electrical panels, where the electrical panels throughout the community were found to be defective, and we had at least one fire with respect to the electrical panels, and we had to send out a notice to everyone in the community that the electrical panels were defective. And believe me, there were some association board members who said, "Friend, this is not our problem. We're not in the business of dealing with electrical panels. Leave us alone." And the answer is no, you can't do that. Even though it's not part of the common elements, you have to send out a notice. And if we don't get proof that your electrical panel has been repaired or replaced, the association, under its power, like the one in Siddons and Cook, is going to come in and replace it for you and charge you back. So you have to be careful with that. We've had cases in high rises where electrical junction boxes were not done properly. So the box on the wall in a utility room and the association in that case would probably, if it was a common or a repeated incident, want to tell the entire community that they all should check their junction boxes. Things get a little more dicey when you think about cracked walkways, right? Generally speaking, associations don't go out and inspect walkways on people's homes, right? In non-common element cases in homeowners associations. But there are arguments that have been raised that the associations would even have to deal with that if possible. The one case that I have seen in that area, the association was found not liable for the homeowner's cracked walkway and or the notice of the requirement to notify of a hazardous condition. Here's another one that you rarely see today, but it's still out there in some communities. I have had dealings with an association in South Jersey where when the condo association was created, the heating was via an underground oil storage tank with respect to every unit. And the condo association knew that those oil storage tanks were at the end of their useful lives and in fact were leaking in many cases. Did the condo association have an obligation to go out and notify homeowners that the underground storage tanks were a hazard and were leaking? I would say yes, they should, right? Because what was happening in those cases were the underground storage tanks were continuing to leak, and the unit owners were responsible for sometimes upwards of $275,000 in environmental cleanup. And the condo units themselves and the people who live there, condo units were not worth the money to repair that $275,000 to mitigate the loss, and the unit owners themselves couldn't afford to mitigate the loss. And there were unit owners in that community that just walked away from their unit. They just walked away from the unit. In those types of cases, I would say the association would have to think about notifying the unit owners. Smoke detectors, carbon monoxide detectors, and especially in condo associations, does the association have any obligation? I'm not sure. To think about when carbon monoxide detectors or smoke detectors expire. In theory, in condo associations, in most condo associations, that would be captured under the DCA 5-year inspection, right? You would hope. But in some instances, they might not. And especially with respect to hardwire carbon monoxide and smoke detectors, there may be a defect in the hardwire system. If the association knows about it, they should tell that the defect exists. Why do some associations resist sending out a notice of a defect like this, even though they may have a duty under Siddons versus Cook? Marketability is often a problem, right? The membership does not want to be told that there's a defect that may cost them money to repair, and they don't want the association to have a dip in the unit marketability or the unit value in terms of resale value. So that's an issue. How have I seen some associations attempt to protect themselves, right? Beyond just sending out the notice. And I have recommended at least to one or two associations that they record a bylaw amendment that just highlights the fact that there's asbestos in the community, right? In particular, right? Because if you send out a notice today that there's an issue with the oil tank, or that there's an issue with the water lines, what does that mean to the person who buys a unit tomorrow? They would not know, right? It would have to be a continuous notice. So how would you deal with it? So in this, I'll show you something here. I'll do a share screen. So this is public notice. So Woodingham is not my client, but this is a resolution that I'm familiar with. It's an older resolution that came out right after the Siddons versus Cook decision, because the association freaked out and said, oh my gosh, we don't want to be liable for damages caused by all this stuff. So they went out and recorded a resolution in the county clerk's office that said each unit owner in the condominium is notified of the following risks. And they have a bunch of lawyer language in there that water can flow from broken bath, kitchen facilities, pipes, including but not limited washing machine hoses, dishwasher hoses, kitchen baths, toilets, etc. What about broken or obsolete hot water heaters? Maybe, right? Smoke damage is arising from fireplaces, flue, dryer vents, etc. Right? Things like that. You may also be subject to smoke and other things. I'm not so sure that that's what the Siddons versus Cook appellate court had in mind. I would say that the Siddons versus Cook court, what they had in mind was not to be notifying the community of commonly known issues, right? Your tub may overflow. Your kids may block the drain in your bathtub and run the water and it may overflow. Those kinds of things. So I'm not so sure that that resolution would cover an association in case of that duty. It's nice to have, but I'm not so sure that a court would look highly on that if we all went rushed out tomorrow and recorded a resolution that says water flows down, right? And sometimes water flows sideways. I don't think that's super helpful. But I would certainly say that if the association is aware of a problem with unit owner items within the community that may do damage to other units and or the common elements, the association should seriously consider and talk to their lawyers about filing a resolution like that that says, hey, we want to let everyone know that we're aware that the popcorn ceiling, for example, has asbestos in it. And before you do anything with a popcorn ceiling, make sure you consult with an asbestos remediation expert. Or let everyone know that the homes are heated by oil heat, and there are oil heating tanks under the ground in front of each unit, and you have to deal with that so that there is not a continuing problem, right? So generally speaking, this is talking about consequential damage, not the cost of remediating the actual defect. So generally the association does not have the obligation to repair the washing machine line unless the unit owner fails to do it. But the initial thing would to be the Siddons versus Cook Appellate Division Court. Their message to the world was the association, in the case of a condominium association, is in the best position to warn of a known hazard. The association is in the best position to warn of a known hazard. So that's the risk. I know many of you are not in condominium associations. Some of you are. This applies, generally speaking, much more to condominium associations as opposed to single-family home communities, but it's something to keep in mind. Let's jump on the chat a little bit. The ice maker feed line, Al D'Amato, I love that. Yes, we have had cases where the ice maker feed line pops and floods. Jeff Schiffman says duty to notify, duty to warn, same thing. Haven't seen you in ages. How are you? I'm good. I'm doing well, thanks. I actually lived in an HOA that required the purchase of flood check braided hoses for washing machines specifically to protect against liability. Yes, Ivan, that's a very good point. Many associations, especially in the high-rise communities, require proof that you've installed flood check hoses. Flood check, I think, is an actual brand, and they may have had some problems with their product, but the point of, I think, Ivan's comment is that there are washing machine hoses that do prevent or mitigate the risk of washing machine hoses splitting and then flooding. And especially in age-restricted communities, especially where there are a bunch of snowbirds that are away. I mean, think about it. If you have a washing machine hose that splits and that water is on and your washing machine is not working, that water flows and flows and flows and flows. And I've seen homes where the water, and you may have too in your life, it's flowing out of the door. The water is actually flowing out of the front door, right? It's a disaster.
Grant, we had one time where this had happened. It filled the basement and finally worked its way up to the first floor and came out the front door. And that's how the neighbors realized it.
Right.
Middle of winter.
That's correct. And it's thanks, Mike. It's insane the damage that can be caused. You know, it's one thing if it's a townhome type unit, but once you get into stacked units, the damage gets insane, right? In townhome units, as Mike said, even in a townhome unit, you're going to wind up with floods through the firewalls on both sides. It's going to impact the common elements as well as the adjoining townhomes. So again, drop a footnote here. You heard this last week. We're in November. If you are aware of units that are vacant, work with your property management company to have them winterized. Make sure they're winterized. Otherwise, you're going to wind up with broken pipes. You're going to get the phone call at 2 o'clock in the morning that the unit is being washed out, and you got a major problem on your hands. Oh, hey, Chip. I didn't even see Chip was here. The association potentially gains a duty every time anything goes wrong that could cause damage, and the association management hears of it. That's a lot of notifications and a lot of resources. Ed, you are so right. You are so right. The courts have increasingly imposed or found duties to the association, and that's why I titled this not our job, not so fast, because prior to Siddons versus Cook, what associations would have said was the same thing the Country Place Condominium Association said. What are you talking about? We don't fix dishwashers. Leave us alone. Right? That was the answer. That was the answer. Leave us alone. The ice maker water supply line, why would we care about that? We're the association. We're responsible for common elements. Leave us alone. So you're right, Ed. The duties grow and grow and grow. And I mean, there are some people, without getting political, would argue that that's a shift in society as well, right? It's always the other guy's job, So the Pacific, Jeff Schiffman says the Federal Pacific electrical panels. So yeah, that's we've had that issue. That's kind of one of the instances I've been referring to where there was an issue with old Federal Pacific electric panels that had to be replaced. There was a fire risk there. I think Jeff is probably old enough to remember. We had a number of cases where the unit owners owned the outlets in the units, and there was pigtail bimetal connections. So they would have copper wiring spliced with aluminum wiring. The wires would corrode at the splice, spark, and start a fire. And the associations at the time were aware of the bimetal joints and the splices, and the associations in many cases took the position it's not our problem. Under Siddons versus Cook, you would at a minimum have the duty to warn. And if I was the association's attorney, I would say send a notice right now that unless those splices are corrected, the association is going to come out and do it and charge you back. How about cases of mold in certain models and areas of the association? That's a good question, Bill. And we have a case on that. I have a case on that. I don't know what the name of it is here. Mold. This is it's called Mackay, Makai versus Winston Towers 200 Association. And in that case, a unit owner, just like the Siddons versus Cook unit owner, tried to claim that the association and the above unit owner was responsible for mold. The Mackay in that case lost in his claims against the unit owner and the association, because the court said you have not been able to show that there was a particular condition that your expert plaintiff traced to the association's problem, or that the association was aware of the problem. So in that case, there was a mold claim, there was a water infiltration claim, one bathroom above the lower bathroom, and the plaintiff in that case lost. But you're right that Bill, that the claim can be made and would be made. Like, so for example, in Siddons versus Cook, there could have been a mold issue there, and certainly Mrs. Siddons would have been pursuing a mold claim if it wasn't resolved before the mold developed. So you're right. It's a risk. It really depends a lot on the case. At my mom's condo, when she's away, we shut off the water. At the inlet stop, we occasionally check that it actually closes fully. This recently exposed a faulty meter, logging use to the account while shut off. Yeah, that's great. That's a good idea. Shut off the water. A lot of people who have seashore homes do the same thing. They shut off the water. Sometimes they get their pipes blown out. They turn off the heat and everything. But at a minimum, have that water shut off and winterize it. The reason why in vacant units, you know this, is that we look to have them winterized rather than just having the water shut off. So what happens is the water freezes, right? The water freezes in the line if they're not blown out, even if the water's shut off. It expands. When the water expands, it jacks the pipes. The pipes have splits in them. And then when someone comes in the spring or summer and turns that water valve back on, the water just blasts out of all the splits all over the place, right? So that's why especially in cases where they're vacant units, you want to winterize it, not just shut off the water valve. Brenda says, in a condo which is a quad and one is empty, should the management company be authorized to go in and check for flood or any other hazard? I would say yes, Brenda, that if you have a vacant unit in a quad condo, you should check on the unit, especially as winter is approaching, because even if it's a single-story condo, if a pipe does pop in there, it's going to impact the adjacent units. So I would check that out. Certainly communicate with the unit owner if the unit owner is still reachable. In a lot of these cases, we see estates where the unit owner may have died and no one is handling the estate yet, and nobody has a handle on what's going on. So that's a good point, Brenda. So if you have, even if it's a quad style condo and it's only one floor, if you think there's an issue with the place not being winterized, I would suggest the association give proper notice and then go in and winterize it and charge them back. So that was fast. That was only 42 minutes. That's all the questions. I know most of you, I would say the majority of you are homeowners, single family homeowners rather than condo owners. But if you have any questions, let us know. And just be aware that whenever you hear somebody on the board or the management company say, hey, that's not our job, that's a unit owner problem, think about the case of Siddons v. Cook and ask yourselves, should we be sending notice out to the membership that we are aware of a common unit hazard? Okay, does that make sense, everybody? So it's a pretty simple approach. It's just something that sneaks up on most associations because the governing documents say that the unit owner items are the problem of the unit owner. And most people say, not our problem. Well, Siddons versus Cook says, at a minimum, you have a duty to warn if you're aware of it. So I want to thank everyone for attending. It's great to see everyone. I hope you had a happy Halloween, and I hope you have a happy Thanksgiving. And speaking of Thanksgiving, thank you all so much for attending these First Fridays with Fran all year and sending in your dogs. So it's great to see everyone. Hope you have a happy Thanksgiving, and we will see you next month.